everyone. Welcome to our training on paths out of care. This is part of our series on the care process to help you better understand what that looks like. Today we have three main sections of our training. The first one is supporting successful transitions from care. That can be used regardless of what the path is. We'll also spend some time talking about psychiatric advance directives and their role in care transitions. Then the second section will really focus on those main pathways out of care, namely voluntary engagement, and for those that have a care agreement or a care plan, and talk about specific scenarios and situations. The third section will focus on other paths out of care, and managing what those could look like, and then focusing on continuing to offer services and supports to support an individual's recovery. Some of our learning objectives today is that you will have a better ability to identify and support pathways for those transitioning out of care, assessing when reappointment is appropriate, and then applying appropriate person-centered approaches to regardless of the specific pathway out of care in a way that respects the respondent's autonomy and supports their recovery. Today's presentation will be presented by Dr. Deborah Rose, a licensed clinical psychologist with HMA who has a history of scaling and designing new initiatives in behavioral health services, and also by Leela Kapoor, who is our mental health law lead and has over 30 years of public service as an attorney representing Los Angeles County and Los Angeles City, and has experience as counsel for the county's departments of health and mental health. So now I'll turn to this live discussion that Dr. Rose and Leela Kapoor had regarding paths out of care.
Thank you, Patricia. And hello, Leela. Thanks for joining me here today.
Hello, Deborah.
I think that we can get started. So let's jump to the next slide, please. We're going to talk about transitions through care, and we're going to talk about Anika. As we often do, this is a made-up person. She may seem familiar with folks that you've worked with in your community. She is not real, though. And we're going to use her throughout this presentation. So please think about some of the specifics as we go, because again, we're going to talk about her in various ways and really infuse her throughout the next hour. So let's talk a little bit about Anika before she became involved in the care. Anika is a 40-year-old woman who's been living with schizophrenia. It started in her graduate school. A little bit earlier, she began to experience symptoms, did well in high school and college, again, was in graduate school for writing. At that time, she started experiencing really significant symptoms, including hearing voices other people didn't hear. She had a number of delusions, and it was impacting her functioning significantly. And all of that really interfered with her ability to maintain her schooling. She left school. Ultimately, she ended up unhoused and was living in a car, not hers, a number of years. And she's had multiple experiences with psychiatric providers, including multiple 5152 holds. Nika really always did well when she was in the hospital, and she was successfully stabilized on meds. And she continued to do well in the community during those episodes. But over time, she would stop her medication and decompensate. And so we've really seen this up and down picture of Anika throughout a number of years. So that's a little bit about her before care. And let's talk about what happened with care. So with care, Anika really had the opportunity to be connected to a team, and this followed lots of assertive outreach and engagement, a number of efforts to work with her in the community. She was really initially reluctant to become involved, but over time, she has developed this relationship with her treating team. She's also been started on medication, which appears to have some good effects. She's taking her medication with support and with supervision and with that extra hand of the team that's really providing her that kind of support. She's reported decreased hallucinations. She's not hearing the voices as much. And when she does hear them, she's able to recognize that they're in fact voices and that they're not real often. Less delusions, less paranoia. She's really just seeing a reduction in symptoms, and at the same time, her functioning is really improved. With the help of the care team and with her providers. Anika has found supported housing and she's doing well in her supported housing. So we've seen a lot of change in a short time during the care process. And I'm intentionally not saying if Anika has a care agreement or a care plan. And the reason that we're doing that is that we are going to use Anika as this example throughout today's training when we talk about paths out. So it really doesn't matter at this point whether she has an agreement or a plan. We're going to go back to her frequently. Then the next slide, we are going to just quickly reference, this is a visual that you've all seen many times before. What you'll see here is that there's different ways to obtain services throughout the civil court. It's also multiple ways in which a person can transition out of care. And so we're really going to be focusing on those various attempts, the bottom of the screen in orange and the right of the screen in those hexagons as we talk about transitioning out of care. I think that we can move forward. And as we often like to do, and will continue to do, is we really want to think and lead with some of the best practices about supporting people out of care. So as we talk through the specifics, think about each of these and how they're appropriate in various settings and various transitions. Certainly beginning early, whether this means that somebody is agreeing and thus the care petition may be dismissed from the court, or whether somebody is going on from an agreement or a care plan, talking about those transitions, preparing for them early, documenting them, go over them multiple times to ensure that really all of the providers, the respondent, the county is on board with this transition and rehearsing it. Thinking about things like graduation and PADS, I'm going to talk about psychiatric advance directives in a moment. All of that should begin early and should be continued to be reflected throughout the care process. Certainly using a trauma-based approach and really considering the individual's voice and choice. What's that person's preferences? What are their needs and wishes? What are their goals? What are they hoping to get from the care process? What kind of treatment is the individual interested in? And because I mentioned PADS, I'm going to do it again, how are those voices and choices represented and documented in writing? We continue to reinforce strength-based language and strength-based approaches. What's going well, as opposed to somebody failing out of care? What are the connections that are being made that can be celebrated? And what's the growth that can be recognized? I think part of the transition is also really ensuring continuity of care. And so that means that services are in place without interruption. There's no gaps. Even if there's a change in providers, we know that that warm handoff has been made, an appointment has been scheduled, the person has been seen, the providers are talking to each other, really ensuring that and I don't know another word for continuity, so I'm going to say it again. Continuity of care is provided so that that person does not lose services and doesn't get lost to services. And some of that really is also about ensuring that benefits and coverage for those new services or those continuing services are in place. Certainly thinking about natural and chosen supports, who is part of Anika's life in this case. I failed to mention, although it was on the previous slide, that Anika had started to reconnect with her family. And so those might be people that she would like involved in her transitions to ensure a smooth shift to another provider or ongoing provider. So really including natural and chosen supports in the process. And then finally, talking about psychiatric advance directives. I'm going to go into more details in that in just a moment. So I think we could actually go to the next slide. Psychiatric advance directives. So a psychiatric advance directive is a legal document. This is an opportunity to write down and witness what's important to the individual. It's really a self-directed document, so a person can write or help express what they want to happen at a time that they're perhaps not in a position to make decisions for themselves. So it could include preference about choice of medication, hospitals, what happens to the pet if somebody is hospitalized, who's going to continue to pay the rent, who do they want notified or involved. It could also include things like, here's how you might approach me, or here are things that I respond to in a better way. Might include, again, I mentioned medications. I don't do well with this medication because I have side effects. I prefer this medication instead. And so really, this is an opportunity. It is not a one and done. You can continue to revise the pads over time. So it really can be introduced in the beginning and can be reintroduced or reflected on or even changed throughout the care process so that there is one ideally in place as a person transitions out of care or into a different stage. And so if you're interested in more information on psychiatric advance directives, there's a link at the bottom of the screen, and we have some dedicated resources and training on advance directives. So I think we will move to the next slide, and I am going to turn to you, Leela, with great pleasure and ask, so if you are part of Anika's care team, what would you start doing now, early on, to help her prepare for an eventual transition?
So, Deborah, you did a really great job of setting this up, and you went through a lot of the things that we should be considering for Anika and anyone that's transitioning out of care. It's important to note we're going to talk later in the presentation about the specific pathways out of care. So this is a more generic best practices discussion around Anika. But for instance, as Deborah's pointed out, one of Anika's issues was that she didn't have stability in housing, and she was able to accomplish that as part of the care process. So you want to assure that that continues, and that might making sure that the housing manager is involved, a case manager is involved. You want to really rely on what she's relied on. It seems that Anika has found a support group, maybe her family members, maybe volunteer or peer supporters. If that support group is in place, you want to make sure that it continues in place. Most importantly, you want to hear what Anika has to say, and you want to hear it early on. Deborah mentioned that transition planning should start almost at the very beginning. And depending upon where Anika transitions out of care, and it could be early in the process, it could be later in the process, you want to do as much preparation as you can, not only to get things documented and in place in warm handoffs, but also get her understanding what is going to be expected of her when she transitions out, how things might change, how they might not change, so that she can start feeling comfortable with the concept of transitioning out of the court process, which provides structure and provides oversight, and transitioning into a venue where she's a little less supervised and has a little less of that structure. So you want to start preparing her for that as well, as much as you can.
Thanks, Leela. Tell us a little bit more about Paths Out.
Okay, so let's go through the various paths out of care. Again, you're going to see this visual several times, mainly just to provide some context as to where we are in the process. The first path out of care could happen very early on in the process, and this is voluntary engagement. I think all of you know that care really does stress that we should be working with Anika to engage her in services voluntarily as soon as possible. And it could even be before the care process is actually started. But once the care process is started and the petition has been filed and the court determines to proceed with the care process, prima facie has been met, it could be that Anika has engaged successfully in services and that she's receiving those services and she's participating, and behavioral health and the court agree that she no longer needs the court structure and the case can be dismissed at that point. So I want to spend just a little bit of time talking about when it might be appropriate to think about this early dismissal out of the process based on voluntary engagement. You want to look at whether Anika has shown a real desire to continue care and that she's comfortable continue receiving care and accessing services, and she's comfortable doing it outside of the care court process. So what is she thinking? Does she think the process adds anything to it? Does she benefit from it? Does she want to continue in it? Or she's comfortable continuing receiving services outside of it? Is she participating in those services actively? Is she aligned with behavioral health and the service providers in what type of services and support she's needs, and whether she's comfortable with those services, and there seems to be a real kind of commonality as to what everybody believes is in her best interest. And then you want to look at her clinical and functional improvement. Has she had some? And so, and if she has, does that indicate that she's ready to transition out of care? So I'm going to turn to Deborah for a second, and Deborah, if you could talk a little bit about what you might look for as far as clinical and functional improvement that would cause you to believe that she's ready to exit the care process.
Yeah, thank you. And I think you led into this really well, is what are we thinking about in terms of her stability and her functioning? She does not, and she may never be cured of schizophrenia. It's certainly a lifelong course, but she is now living in recovery with schizophrenia, which may mean that she is able to recognize some of the symptoms. Even if she's experiencing them, she could recognize that there are symptoms, articulate perhaps when they come or what she does to perhaps manage them. So maybe the voices don't go away, but she's able to say, these are voices that aren't real and I don't need to respond to them. We might see that she's potentially more willing to take medication. Of course, that's not always the case, but that's a possibility. Sometimes just even with support, right? Perhaps she's not taking medication independently, but she's willing to have a doctor in the community give her an injection once a month. We might start to see increased functioning. She's now living in supported housing, and she's meeting with the case manager, as you said. So we would look at all of those things to say, this is not somebody who is without symptoms, but we're certainly seeing a reduction in the symptoms, reduction in the frequency, reduction in the intensity, and it's really somebody who's beginning to engage in services.
So let's just reinforce that if Anika is at that point and everybody agrees, including the court, that she has successfully engaged in the services and we're seeing the progress and the improvement that Deborah just went through, then you need to start thinking about, we should have already been thinking about transition, because you want to assure that the progress she made doesn't end if the case is dismissed. So maybe at this point in the process, continuity of care is the most important. And so we stress that that is a transition process that you really need to be thinking about and making sure she's on board with it and that she understands the expectations and the goals associated with transition.
Yeah.
We're next going to move to a care agreement. And the reason that we're starting with a care agreement, even though it is not as structured in the CARE Act as a care plan, but we understand that the vast majority of cases throughout the state are being handled through care agreements. So this is what you are all seeing in practice on the ground. And so we want to kind of start with this as part of our discussion about transitioning out of care through care agreements and care plans. As you all know, a care agreement is an agreement that the individual, that Anika, has worked with behavioral health to develop and has agreed to, and the court has approved. And the care agreement sets forth the services and supports that everyone feels that Anika could benefit from and that are available for her to access. And under the statute, the court is to set a progress report within the first 60 days. That's what the statute requires. We understand that in many counties, the courts are keeping even a more close eye on progress through care agreements. They're setting more progress hearings, maybe more frequently, to allow for them to provide oversight and structure and encouragement to Anika so that she is successful in complying with her care agreement. We're going to talk a little bit later about what transition out of care agreements could look like in combination with our discussion about care plans. But again, it's just really important to know that when that care agreement ends and the court dismisses the case, there needs to be a continuity of care plan. You can call it a graduation plan, a transition plan, a continuity of care plan. Basically, what it is doing, it is setting forth the services and supports that Anika can expect to receive and should be hopefully willing to participate and access so that her progress continues after the care court process ends and after that structure no longer exists for her. So going to the next slide, transitioning out of a care agreement. What do you consider when you're thinking about Anika and whether she's ready to transition off of a care agreement? I think it's probably pretty obvious. We've discussed some of this in an earlier discussion, but you're looking for the progress she's made on the care agreement. including how behavioral health assesses her stability at this time. You're looking at the services and supports that were set forth in the care agreement. Have they been provided to her, or have they not yet been provided to her? And if so, if they haven't been provided, would it make sense for the care agreement to continue for a period of time so that we can assure that those services are made accessible to her? And is she engaging in them, and is she positively interacting with the service and the service providers? I would mention that a care agreement does not have to go for the full year. You can transition out of a care agreement at any time that the court and the individual and behavioral health feels appropriate. So it does not have to go for the full year. And you also want to look at whether she continues to meet eligibility criteria. If she no longer meets the eligibility criteria because she has made such improvement and progress, it may be that a really good indicator that she's ready to transition out of the care court process. So I'm going to bring Deborah back into the conversation and ask if you could maybe, Deborah, just talk us a little bit through the care criteria and what ones you would specifically be assessing most, you think that might be the most important to consider at this stage of the process.
Yes, Leila, and I think they're the same ones that we just talked about, right? When we talked about if somebody was agreeing to services early on, may have jumped the gun when I talked about some of the progress that she has made on that. So I'm going to just reiterate it here a little bit. Is certainly I would look at her clinical stability. How is she doing? Is she able to recognize symptoms? Is she able to maintain her symptoms? Is she able to address them? And how do they impact her functional ability? Is she tending to herself, to her finances a bit? Even with support and structure, doesn't mean she has to do it on her own. She's perhaps seeking or engaging or maintaining housing, working with providers. So all of those things that we would see with somebody who is beginning to or is living in recovery as factors that we would say, this is somebody who may be ready to transition from a care agreement. What's really important here is that she's also, and you've said this a number of ways, that she's also agreeing to what that plan is going to look like, and that she will likely continue to work with her treatment team, whether it's an ACT team, an FSP, providers in the community, housing, etc.
So let's move now, Deborah, to care plans. So the next slide shows us again the visual. Care plans are much more structured than care agreement in the statute. The statute specifies specific steps and processes that need to be implemented with a care plan, including getting through graduation. So we're going to walk through what the statute sets forth for care plans, but because we recognize that most counties are dealing with care agreements, I would ask you just every time I say care plan, think care agreement and think, is this a process or a principle or a step or a methodology that we could also use for care agreements? And what we're hearing is a lot of counties and courts are doing just that. They're taking the principles that are set forth in the statute for care plans, and they're using them because they think that they make sense with care agreements as well. So keep care agreement in your mind. When I say plan, you think agreement too, please. Moving to the statute around care plans / agreements. The first thing that happens when somebody is moving and progressing through a care plan towards the end of the first year, there is a 1-year status report. It's called a 1-year status report. It actually is created prior to the year, so it's like at the 11th month. It's a report generated out of behavioral health, and it's a report to the board on ANICA's progress on the plan or the agreement, if we're going to use this for an agreement. And it really discusses where she is right now, what her like a final assessment of her stability. Talks about the services and the supports that were provided to her and those that weren't provided to her. It should talk about any challenges that ANICA has shown with adhering to the plan and some reasoning maybe behind why she's had these challenges and how they could be overcome. And then a recommendation from behavioral health is what they think as far as additional services she may benefit from and what they think should be the next step for ANICA. And so that report, if we can go to the next slide, is heard by the court at a 1-year status hearing. Again, statute calls it a 1-year status hearing. It's actually held at the 11th month. And at that hearing, the court's going to review the report it's received from behavioral health, and consider anything else that is in front of it. And then the court can do one of three things. The court can, if we can move on, can voluntarily reappoint Anika to the care process. What this means is that Anika has said, hey, I'm really benefiting from this process. I'm feeling good about it. And I think it would really help me to stay within the structure of the care court process for a period of time and continue to receive services pursuant to the care plan going forward. And if the court agrees with that and believes that Anika will continue to benefit from continuation of the process, the court can reappoint her to care for up to a year. It does not have to be a full year, but it can be no longer than a year. The other thing that the court could do at this point is involuntarily reappoint Anika. This would happen if Anika hasn't expressed a willingness or desire to continue in the process necessarily, but the court has looked at the situation, has determined that she hasn't successfully completed the care plan at this point, or the care agreement, and that she would benefit from some additional oversight, some continued oversight, and the court structure and all that it provides. That she was actually provided the services and supports that would set forth in the care plan or the care agreement. So those were made accessible to her, and that the continuation would really benefit her going forward. And in that case, the court could involuntarily reappoint her to care for, again, up to a year. The third alternative that could happen at this point is that Anika could graduate from care. And this is the ideal situation. This is after the first year, or it could happen if she's been reappointed and she stays in the program for an additional year. But after the first year, the statute calls for the Department of Behavioral Health Department to develop a graduation plan. And, we're using words somewhat interchangeably. The statute says graduation plan. We're using the word transition plan, continuity of care plan. It really is a document that sets forth all the things we've already discussed. It should be created with Anika so that she is aware of what's in it. She's supportive of what's in it. She understands the expectations. She understands the benefits that she should receive from it, the services and supports that should be provided pursuant to it. And it really reflects her goals and what she wants to see going forward. And it may, as Deborah's mentioned before, it may include a PAD if that's something that has been developed with Anika. The court will review the graduation plan and will, at that point, if everybody's in agreement, the case will be dismissed at that point, and Anika will have graduated out of care. Again, the statute calls for this process for a care plan. Many counties are using the same type of a structure, the graduation hearing for care agreements. And there's reasons for that, not just the documentation that it provides and the court oversight it provides, but it provides some intangibles as well. And so with that, I'm going to move to the next slide, and I'm going to pull Deborah back into the conversation. And I'm going to set the stage that Anika had entered into a care agreement. She did really, really well on it. She's at the point, let's say, after her first year, and the county is kind of using the care plan model, even though it's a care agreement, and everyone believes that she's ready to graduate. So what does her graduation plan or her transition plan look like? And how does a graduation hearing benefit her in a kind of intangible way? How does it motivate her?
Yeah, I love the second part of that question. So thank you. I'm happy it's there on the screen. And as you said, counties have a lot of discretion in what they're doing, and a number of counties are using the statute-defined graduation for a care plan in the care agreements. And so what that means is that they're taking the same approach, which really begins with, at that point, that that they're talking about it, a collaborative meeting with Anika, with her public defender. It could be the county BH, or it should be the county BH team, any providers that are involved in her care. Again, we want that continuity to be certain, and any natural supports, peers, others that she's chosen. So really bringing people together reviewing her progress towards recovery, towards treatment, looking at improvements in all of those areas I've been talking about, clinical stability, improved functioning, community connectedness. I also think a really important part, and we don't talk about it enough, is a purposefulness, right? She has some ideas, some goals, and is able to talk about them a little bit. And so what we're seeing is that this play on the graduation plan would be developed together. It would ensure that there is no interruption in services, so that either new providers or providers that are continuing to work with Anika after she graduates are in place. They might be talking about a psychiatric advance directive, and if one is completed, even who's keeping a copy of it, really basic things, and then partnering with the providers to ensure that her voice and her choice are heard in that progress. Um, what I think is really interesting in the question that you asked is like, why the graduation plan? And we see that it's such a wonderful opportunity where people can be celebrated for their successes, for the accomplishment, for every step that has been made towards individual recovery. And it has, I think, I've seen graduations in other courts, and I've seen where respondents have come in with their babies, or I've seen where somebody has come in with a guitar and has played a song with the judge. And it's a really meaningful moment. We've seen some of the video, we've seen the video of what's happened in San Diego. And it's inspiring not only for the individual, but also the county BH teams and others who are involved in it. So I think any way to celebrate what matters to the person. We've heard one judge that we've talked to say, if the person doesn't ever want to come back to court, we're saying, fine, you know what, it's your graduation, that's how you can do it. And so it's just, I think, an opportunity to think about all of those best practices, which is really, ensuring that it's written down, that people are coming together, that there's coordination, and most importantly, that that person's spirit and choice and needs are present. So
And
I
it,
would, oh, please.
I was just going to say, and just adding on to what you said, there's so much a sense of accomplishment with this. And that's what drives a lot of us to feel like we have purpose, that we've accomplished something, and that we have overcome obstacles. And so a lot of people, a lot of counties are using the graduation ceremony as a recognition of the accomplishment of the respondent, and as you said, just graduating them out of and celebrating the graduation much as you would out of any milestone in your life. I would also say that we've heard some wonderful stories. Deborah alluded to a couple of them, of courts throughout the state who have just embraced these concepts. And so again, just to repeat, because I feel I need to, is the statute doesn't provide for this in with the detail that we've discussed, certainly not for care agreements. But so many courts are understanding the significance of it and the benefit of it, and they really are embracing the whole model for the agreements that they are monitoring. So I think it's really wonderful to hear that the courts have been that flexible and that understanding and really buying into the concepts behind it, the ones that you talked us through, Deborah. So we're encouraging that and hoping that everybody else will kind of jump on board.
Absolutely. Yeah, absolutely. We've heard of certificates, right? We've heard of flowers. We've heard lots of things, which I think is really wonderful for folks to celebrate those milestones, as you've said. So let me take us in a little bit of a different direction, if I can, and start to talk about other kinds of pathways out of care. And specifically here, we've been talking about care at the end, other than the early agreement. We've been talking about when we might transition out of care after an agreement or after a plan. But let's talk about other paths where it doesn't necessarily happen at the end. It could be happening at any time throughout the process. And if we go to the next slide, what happens when people move for various reasons? And it's happening a lot. We get a lot of questions. What happens if Anika is no longer residing in the county where there is where the petition filed, where there's a care plan or an agreement? And so the short answer of this is that if she consents, and again, this is an important part to recognize client choice. If Anika consents, the court proceedings can be transferred to another community. In that situation, with Anika's consent, County BH should work with their legal team, whether that's the county council or others. They should notify their court. And so that would be an opportunity to work with the court and with the judge and with Anika to try to coordinate a transition to the new county. In that case, they would notify the new county behavioral health agency and the new court. So together we would have these entities that are working to ensure that, again, there's no gaps in services. Ideally, there'll be a new set of providers in the community. There'll be a warm transition, a warm handoff to those providers, meaning not only has an appointment been scheduled, but she's met the new providers, she's been accepted into services there. There is that thoughtful continuity that's taking place. And the care agreement or the care plan can also be transitioned to the new county. Along with potentially any relevant documentation to support it. So with her consent, a lot can happen. And again, I'm making a suggestion that in this case, Anika is moving far enough away that she has a whole new treatment team. That might not be the case. Perhaps she's moving to a new community and keeping some of the same providers. But the idea is that because she's consenting, County BH and the court can work with the new County BH and their court to successfully ensure a transition. Now, there may be situations where Anika does not consent to that transfer. And in that situation, the proceedings will continue in the original court and in the original county. So even though perhaps Anika is living elsewhere, the original county where the petition was filed and where it's held will still be responsible to ensure that services are coordinated and that they're managed across the jurisdictions. Leila, anything I'm missing from that one?
The only thing I would mention is that for those of you that want to know a little bit about how the notice provision, how the notice is provided both to Anika and to the receiving county, 7.2223, and that will help your counsel, your legal counsel, kind of navigate how the specifics work.
Thank you for that, because I definitely would not have known that, and nor have I would said it. So let's talk about other ways that transitions might happen at any point during the person's care involvement. And I think that we can go to the next slide. And with that, let's talk about what happens if a person is either hospitalized or incarcerated. And we've received many questions from the counties about both of those situations. Interesting to note that in both situations, potentially, there is an unknown period of time. And certainly a couple things we'll note is that hospitalizations generally aren't that long, and incarcerations, the average is 1 day incarcerated in a jail. But certainly we can see longer hospitalizations, we can see longer incarcerations depending on charges or conditions. So there's a lot of unknown that can go on in both situations. And certainly if we're talking about long-term hospitalization, more unknown. So first thing I want to say is that neither of those situations trigger an automatic dismissal. And I want to pause with that and say that again, just because somebody is in jail or in a hospital is not automatically create a dismissal, nor should it. There's a couple thoughts that should go into that, including if you can assess how long a person might be in a hospital or incarcerated, sometimes that's really helpful. Obviously, it's difficult to predict, but it might not automatically trigger action. Can you continue to provide services, right? If somebody is in a hospital, can you visit the individual? Or if they're in a jail, can you be that familiar face to the person? Can somebody from the treatment team visit that person and be part? Can you be part of the treatment planning process? Can you notify the jail medical provider of what's going on so that services can be uninterrupted in the jail, perhaps medications continued? And as importantly, with both the jail and a hospital, can you make yourself and the care involvement known so that their discharge planning can come back to the treatment team and can come back to the care team so that you're part of it. So really important to continue to provide and at least offer involvement with both Anika and the treating teams in both situations. Is Anika still willing to engage with you? Right, despite being in a jail or hospital setting, does she want to continue your people that she's familiar with? Potentially there might be some other legal issues. I'm not sure what they are, but certainly you might consider, let's say, if there are charges in another community or another county, that might complicate things a little bit. And really, is there a risk to losing services? Can your presence help to ensure that services are continued? And is there a possibility that without that, or without even the ongoing care case, would a dismissal of care impact that person's services or housing or treatment team? So really, again, not an automatic dismissal, but thinking through some of these issues. And so as one thinks through the issues and as your county works through the specifics, County BH should work with their counsel to notify the court of what's going on. That could be through a progress or a status hearing. You can ask the court to set aside a hearing to talk about it. Ultimately, it is at the bench's discretion about whether the proceedings are dismissed, or if they're allowing the petition to continue or allowing the agreement or plan to continue. We have heard frequently from judges that some judges are very patient and don't want to see a disruption in services. And so they are allowing the care proceedings to continue to see how that person is doing. And, ultimately, after the incarceration or hospitalization, after a discharge, should be discussions about if care is continued and if there should be a different set of treatment provisions within the care proceedings, within the care plan or agreement. So, seems like it's a case-by-case basis for a lot of folks. And Leila, I think I got it.
I think you got it.
Excellent. Let's move on then. Thank you. What happens if someone is not participating in care? And at any time that can happen, the person is maybe not participating early on, or they are already within the middle of a care agreement or a care plan. At any point, the court could terminate a care plan or an agreement. And it's important to know that they can do that. That non-adherence or can be considered in later LPS hearings. Medication, declining medicine alone will not should not be considered in future hearings. But again, somebody who is unwilling or unable to participate in care can be considered later on down the road. It's not an automatic. There's a presumption that additional information is needed. So it's not, not an automatic trigger for an LPS hearing, but these are some considerations. If the court has had a plan and not an agreement, I'm actually just going to put that aside for a moment because I think the situations are very similar. The county can continue to provide outreach, certainly can continue to try to engage the individual in services, even if it's outside of a care plan or a care agreement. And so I think we're hearing that from counties that some of them are fairly patient about this. We've heard more than one judge say, in spite of this person's non-adherence to the plan, we're going to give you some more time. Go back into the community, see if you can engage her. Try again. Maybe get somebody who is better at these outreach skills. Look for other people, a peer, a mobile crisis team, a homeless outreach provider who may be able to do it. And so I think that there are a number of opportunities. Ultimately, this is something that is decided with your county council, and it's at the judge's discretion.
So Deborah, if I could just jump in quickly, and it says it on the slide, but I just want to reiterate it so that we don't get questions around it. The failure to participate in either a care agreement or care plan can certainly lead the court to terminating the case and ending the care process. But as you've said, many courts are really trying to give as much latitude to that as possible to continue to engage the individual and see if they can be successful in their agreement or their plan. The implications that you discussed as far as the LPS implication in a subsequent unrelated LPS hearing only apply if the individual has failed to comply with a care plan. And it says this on the slide, but I just want to reiterate it because we are seeing mostly care agreements out there, and I just want to make sure we're all on have the understanding that that implication does not apply to a care agreement.
Thank you. That's a good pickup, and I appreciate you calling that out. I do want to stress, though, and because we have heard it, that this really is the opportunity when there is latitude to continue to do outreach. And even if a plan or agreement is dismissed, you can continue to work with the individual, continue to do outreach, continue to make efforts to engage the next time you see the person. And so I think that it's an opportunity to really keep working with folks who might benefit from the added structure and support that can be provided. I think let's take us to the next slide, please. And let's talk about, again, these transitions. We're sort of jumping into it, but whether it is a dismissal or a transition or a graduation, what are some of the things that you can continue to do? What are some of the things that actively you can do? I'm talking a lot about continued outreach and engagement, trying to build trust and engage the person in services. If you have teams, many of the counties have teams that do that. Many of the smaller counties know the individual personally and can continue to do that kind of outreach. You can think about other programs, whether it is, again, ultimately with a care plan, consideration of LPS, could be AOT, could be mobile crisis workers or others who may be able to connect with that person in the community, and still providing those services whenever possible. And also important to note that you can keep working with the chosen supports, the family members, peers, volunteer supporters who are involved in Anika's case. And so the end of care doesn't necessarily mean that it's the end of continuing to try to support the individual. I think that's what I'm trying to say, is let's keep offering whatever we can to hopefully engage with the person in their recovery or bringing that person into the journey of recovery. So with that, as we like to do, one more. Ideas in action. And this one, Leela, is for you. We've talked about it a bit, but let's wrap it up with what strategies can counties use as you continue engaging respondents like Anika after the case is dismissed or closed?
So yeah, we've discussed this a little bit, and so I'm just going to emphasize a couple of points that you already discussed. But in this situation, we're discussing the fact that the case was dismissed or closed either because of non-participation or other disruption in the services, whether it's incarceration, hospitalization, etc. And so it's a little bit different than a transition out of care where there was a successful engagement and you're transitioning out of a care plan or care agreement. You have Anika here who has, for whatever reason, either for her own reasons or because of some intervening event, she has not been able to participate in care. And the court, and as again, many courts are giving a lot of opportunity for that to happen. But at some point, a court might say, we need to terminate this case, and the court will most often, if not always, terminate it without prejudice, which means it can be refiled if the situation changes and it makes sense to refile the petition. But what I think would say the most about this, when you're in this type of situation, the most important thing is to not lose track of Anika. There are
Right.
various touch points, I think, that you will find. All of you are aware of them. Certainly, if she's hospitalized or incarcerated, there might be an opportunity to continue outreach with her. Your community outreach teams and others that are on the streets and engaging with these individuals may have an opportunity to engage with her. She may still access some services, and that's a way to continue talking to her and working with her and seeing if you can get her to more fully engage. And you might get, after some additional outreach and engagement or change in circumstances, you may get her to recognize and be willing to recognize the benefit and be willing to participate in the care process. And you may consider at that time refiling the petition because she agrees and you agree that that structure and that support would be useful and beneficial for her. So bottom line, best as you can, don't lose track of her, and keep on trying.
Yeah, I really appreciate that. And I think that's the spirit of this is, again, with a graduation or plan, celebrating that success and then continuing wherever possible to reinforce the recovery and to be available in her experience.
That was hopefully some information that will help you better understanding pathways as individuals transition out of care. Again, the learning objectives for this session were that you would have an increased ability to identify and support pathways for transitioning out of care, assessing when reappointment is appropriate, and then also discussing person-centered approaches to helping an individual as they transition out of care. And just a note that the slides and also the talking points are included on the website as well, including all the links that were shared. So you can go ahead and click on the training materials so you can have access to all of that information. We wanted to share some information about the CARE Act Resource Center, and then I will share a few specific resources that could be helpful. So our CARE Act Resource Center has our training and resource library, notes upcoming training, has a county directory if you're looking for county-specific information, like links to county behavioral health websites or court websites. We also have a list of FAQs. We have a number of ways to be in contact with us. These are all linked in the training material. But when all else fails, or if you're not sure where to go, you're always welcome to email us there at info@careact.org. Wanted to point out a few specific trainings and resources for you. So there are you see here a list of trainings, and again, these are linked in the training materials. We have a training on pathways to services into care. We also have a training that we referenced earlier on Psychiatric Advance Directives and talk about some best practices and how they can be integrated into care. We also have a series on trauma-informed care for county behavioral health. This includes a number of trainings that talk about how to take a trauma-informed approach throughout care and can be helpful when you're thinking about ways to help somebody transition out of the care process. We also have a training and a brief that's listed below about claiming for administrative activities. Helping somebody transition out of care can be categorized appropriately under some claiming activities. So we wanted to make sure county behavioral health teams are looking through that and identifying what is claimable administratively. There's also a number of data collection and reporting as individuals transition out of care that continue to be claimed for. So go ahead and check out that training and that brief so your team can understand how to reflect that in your claims to LGFD. We also have a training on strategies for outreach and engagement in care. And we talk about how to employ outreach and engagement activities throughout the care continuum. So you can go ahead and check out those trainings. As far as briefs, we have a care process flow specific for county behavioral health that walks through each step. If you wanted more information about graduation or steps throughout the care process, you're welcome to check out that brief. And like I mentioned, claiming for administrative activities. So there really is no wrong door. If you have a question about the information in this training, how to apply it to a county, or you're looking for a resource that's unrelated to this topic, please go ahead and reach out to us at info@careact.org, and we hope to hear from you soon.